Honorable guests, my dear friends, ladies and gentlemen, it is a great honor and pleasure for my colleague Stavros Berkoulakis and I to welcome you to the 4th International Arbitration Forum in Athens, which, together with the other interesting events, forms the core of the Athens Arbitration Days, an institution that embraces all the annual arbitration events in Greece. This year's theme, States and State Entities in International Arbitration, was chosen in awareness of two pervasive arbitration-related issues. On the one hand, the ever-increasing involvement of states and state entities in international arbitration, both commercial and investment, and on the other hand, the relevant jurisprudential developments within the European Union, and as of recently in Greece, these developments require, in our opinion, a closer and careful look. Thus, the theme of today's forum will be elaborated by 3 panels under the subtopics State Participation in International Arbitration, second topic, Representing States and State Entities, and third topic, Representing Parties against State and State Entities. We believe that these 3 subtopics cover all the individual issues that arise in arbitration involving state and state entities. In particular, the first panel will address the drafting of the relevant arbitration clauses, the legal standing of state and state entities, and the recurring issues pertaining to the jurisdiction of arbitral tribunals. The second panel will address all issues relating to the legal representation of the state and state entities in the relevant arbitrations, including the practical but highly critical issues of evidence collection, communication between representatives and public officials involved in the case from which the disputes arose, the issues of budgeting and payment of arbitration costs, and finally, the possibilities of settling these arbitration cases. The third panel will deal with the representation of the parties opposing states and state entities and the problems that usually arise, such as instances of corruption, default of a party, evidence collection, drafting of settlements, and most importantly, issues pertaining to the enforcement of arbitral awards against the state and state entities. As you can see, all panels will focus on the practical issues that arise in the context of arbitrations involving state and state entities. Finally, the fourth panel will deal with a particularly interesting and at the same time problematic development brought in the Court of Justice of the European Union's landmark decisions in Achmea, Comstroy, and PL Holdings, cases within the European Union. The Court of Justice jurisprudence has already been embraced by recent Hellenic Council of States decisions number 246 and 512 of 2022 both, and caused further implications in concession contracts which contain an investment element. The Court of Justice judgment has indisputably caused some legal uncertainty in the world of international arbitration. However, a bona fide observer of these jurisprudential developments may find it hard to understand why the Court of Justice did not follow in the above cases the principle established in the Eco-Swiss, Mostaza Claro, and Asturcom cases, namely that the monitoring of the application of EU law by the arbitral tribunals can be adequately secured at the stage of judicial review of arbitral awards, it is at the stage of annulment and or recognition and enforcement of arbitral awards, in the context of which the EU state courts may also refer to the Court of Justice, European Court of Justice. The reason provided by the Court of Justice for its divergent approach is that whereas commercial arbitration is based on the autonomy of the parties, investment arbitration derives from a treaty by which certain member states consent to be excluded from their domestic jurisdiction and therefore from the system of legal remedies. The second subparagraph of Article 19 of the Treaty of the European Union requires them to provide for disputes concerning the application and/or interpretation of EU law. It is on this rather earth criterion that the Court of Justice concluded that the principle established in Eco-Swiss, Constantin Calavros, and Asturcom cases are not applicable in investment arbitrations such as the BIT ones. Court of Justice reasoning cannot withstand serious criticisms and suffers, in my opinion, on several points. But even under the assumption that the Court of Justice decision was indeed in the right direction regarding the criteria of distinguishing commercial from investment arbitration, this distinction does not justify the extreme measure recommended by the Court of Justice, namely the annulment of the arbitral award due to the invalidity of the arbitration agreement, so the ACMEA judgment, or on the ground of excess of power, so the PL Holdings judgment, without first assessing or being able to assess whether the arbitral award is in fact contrary to the EU public policy. The further development in the Hellenic Council of States jurisprudence was, at least to some extent, expected. With its decisions 246 and 512 of the year 2022, the Hellenic Supreme Court for administrative cases fully adopted the reasoning of the above-mentioned Court of Justice judgment without providing any justification for the shift in Court of Justice jurisprudence as to the distinction between commercial and investment arbitration. However, the particular significance of the two decisions of the Hellenic Council of State lies not in the adoption of the European Court's jurisprudence, this was more or less expected, but rather in the adoption of a novel and erroneous reasoning. In particular, the Council of State, in its aforementioned decisions, accepted, I quote, the relevant arbitration awards are issued in excess of the tribunal's power and consequently are not binding for the administrative courts adjudicating on these disputes, unquote. At this point, it is recalled that according to the Council of State established case law so far, I quote, the administrative court does not have the power to review the issue of the expiry of the above-mentioned contract because this issue entails the annulment of the arbitral award, which can only be pronounced by the competent civil state court following an action of annulment under Article so-and-so. Contrary to said jurisprudence, by virtue of its judgments 246 and 512 of 2022, the Council of State, and in accordance of its view expressed therein, that the relevant arbitral awards are not binding on the administrative courts. The Council of State adopted in reality a generic incidental review of arbitral awards, even when the state court vested with the exclusive jurisdiction to annul arbitral awards have not ruled on the matter, or even when they have rejected an action for annulment. The prohibition of incidental judicial review of the arbitral award was until today well-established Greek law. This position is not affected by the Court of Justice jurisprudence in the Acmea and PL Holdings cases, as the Court of Justice only ruled on the arbitration clause compatibility with EU law without, however, taking a position as to the procedure and specific conditions under which said incompatibility shall be diagnosed. Thus, the Council of States, any Council of States aforementioned jurisprudence does not follow in the reality the Court of Justice relevant jurisprudence. In fact, the Council of State established a generic, again, incidental and unrestricted review of arbitral award, which is against well-established Greek law. I'm sure that the distinguished participants of the fourth panel will elaborate on many more aspects of the aforementioned matters and will enrich the debate on the Court of Justice and Hellenic State of Council's recent case law. So, I'm confident that by the end of this day, we will have gained a better insight and have enriched our knowledge on the subject matter. That said, I would like to deeply thank all those that will contribute to the scientific success of this conference. Had it not been for them sparking the scientific debate on such pervasive topics, international arbitration could not have further evolved. I want to thank and express my gratitude to Sakoulas Publications, especially to my dear friends Panagiotis Sakoulas and Yannis Papagrigorakis, who made it possible for all of us to meet here, and of course our sponsors for their vital contributions. Finally, I want to warmly thank my dear colleague and friend Stavros Bakoulakis. It is an honor coordinating already the fourth International Arbitration Forum together with Stavros. Holding this conference was only possible through his commitment of time and effort. Thank you very much, and thank you very much, Stavros.